Hello, I'm Adam Kielich, the principal attorney at the Kielich Law Firm in Bedford, Texas. Today's short video is going to discuss age discrimination and the ways that employers discriminate on the basis of age. Today we'll talk just briefly about what age discrimination is. We'll spend the most of our time talking about the ways in which employers discriminate on age, and then we'll talk very briefly about the remedies available to you if you are a victim of age discrimination. So let's go ahead and jump into talking about what age discrimination is. Age discrimination in the employment discrimination context is when an employer takes an adverse employment action against an employee or job applicant on the basis of that person's age when they are 40 years of age or older. When you heard that description, you might have asked, what is an adverse employment action? And those are the ways that employers discriminate against employees and job applicants. And we'll get into that later. That'll be the bulk of our conversation. But I do want to highlight just a few other points about that description of age discrimination. Keep in mind that this applies to both employees already hired by the company as well as people applying for jobs, whether they're internal candidates or external candidates just trying to get their foot in the door with the employer. Additionally, the age cutoff is very important for age discrimination. The purpose of anti-age discrimination laws was to protect older workers from being cut out of the job market because younger, cheaper employees or applicants were available. So the cutoff in the law, both federal and state, is at 40 years of age. Once you hit 40, I guess you're officially over the hill, and employers are prevented at that point from discriminating against you, at least on that basis. If you're 39, if you're a day before 40 or younger, you're out of luck. The employer is free to hire somebody older than you and even explicitly say that they're hiring somebody older than 40 because you're too young. Things can get tricky when you're talking about different employees who are both over the age of 40, and maybe one employee or one applicant gets the job over somebody else who's over the age of 40, and when age comes into play between those two jobs. But that's really beyond the scope of today's video, and maybe something that I can talk about in a future video. But for now, just understand that there has to be an adverse employment action by the employer or prospective employer against an employee or applicant to the job, and that person is 40 or older, and the age serves as the basis for that adverse employment action. It's not enough that you're just over 40, but that your age was the basis for that decision making to not hire you or to take whatever adverse action occurs. Age discrimination is unlawful under both federal law, under the Age Discrimination in Employment Act, or ADEA. It's also unlawful as far as state law goes under the Texas Labor Code. If you've been discriminated against on the basis of age in employment, one of these laws or both of these laws will apply to your situation, and you've got the right to pursue remedies under one or both. But before we get into the remedies, let's talk about what those adverse employment actions are so that you've got a sense of the ways in which employers can discriminate against employees and applicants. So obviously, the first point at which age discrimination might affect your employment relationship with an employer is failing to hire or some other act during the application process in which you're trying to apply for a job. Maybe you're an external candidate trying to come in, or you're an internal candidate that works somewhere and is trying to move into a different position. In this case, it is an adverse employment action for the employer to not hire you when age serves as the basis for that decision. The employer can decide almost any other reason why not to hire you. You're too tall, you're too short, you're not attractive enough, you don't have the right employment qualifications, you don't have the right kind of education background. These would all be fine, but The second the employer invokes age as a reason not to hire you, that becomes an adverse employment action on the basis of age, and it's age discrimination. So kind of along that same route, we could talk about the failure to promote. If you're an internal candidate and you're trying to get a promotion to the next level, whether it's a job directly above you in management or it's a promotion into another department or another position, the same thing applies. The employer is not allowed to take your age into consideration as a factor when making those employment decisions about who to hire into that position. On the other hand, an employer is also prohibited from using age as the basis to make employment decisions to terminate employees. This often becomes an issue in layoffs where employers are trying to lay off the most expensive employees, which also happen to be their older employees. But an employer may specifically target individual employees on the basis of their age. That would also be a prohibited form of age discrimination. And similarly, employers are not allowed to demote an employee on the basis of age, whether it's because a particular manager doesn't want older employees working for him or her, or the company as a whole just kind of wants to weed out the older employees at a certain level and push them down to a lower level. That same kind of demotion is going to be an unlawful form of age discrimination. Now, before we move on, there's a very important point to make about the four types of age discrimination that we've discussed. And that's that employers do sometimes have a defense in which these employment decisions actually are lawful. And this is called a bona fide occupational qualification. What that means is if the employer has a legitimate reason that's related to the job why somebody needs to be of a particular age or below an age limit, that can justify not hiring, not promoting, terminating, or demoting an employee on the basis of age, and the employer can just come right out and say that's the case. A common example of that is having a mandatory retirement age for a job like commercial airline pilots. There's a cutoff age at which they are no longer allowed to fly, and that's an employment decision that is made absolutely and exclusively on the case of or on the basis of age. But it's okay because the employer has a bona fide occupational qualification proving that there's some legitimate reason why the job cannot be done by somebody older. That's of course not the only way in which a bona fide occupational qualification can exclude people above a certain age. You can also have jobs that are very specific to kids. For example, if you were shooting a movie and you needed an actor to play a child, you're certainly not going to go out and get somebody who's 60 to play a 6-year-old, right? Like, that makes total sense. And in that regard, the employer or the casting crew or whatever could come out and say, we just need to hire somebody who's of a particular age group, because it wouldn't make sense any other way. So in that regard, if an employer has a bona fide occupational qualification, they can discriminate lawfully on the basis of age. But this defense to age discrimination is really fairly narrow. Lots of times employers make these decisions based upon salary expectations or what they know they're paying salary-wise or benefits to an older employee. If they're cutting simply because it helps their bottom line, or they're not employing somebody because it helps their bottom line, that is not a bona fide occupational qualification. It can get tricky when you've got employees who perform manual labor, because sometimes older people just aren't capable of performing the job. But if the employer is sort of setting a hard cap on age for the job, or just insistent that older people can't do the job without a particularized reason why an applicant or employee is incapable of doing the job as it relates to actually performing the work, that would be an unlawful form of age discrimination. Now, if the employee or applicant physically cannot do the job, and it's clear that regardless of age, that person just lacks the physical capability to perform the job, that would not be an unlawful form of age discrimination, because the employer is making a decision based upon the actual performance of the job. Employers also cannot set up illusory hurdles that are designed to make it difficult for older people to get into the job. Good examples of this are employers who talk about wanting youthful, excited, exuberant employees, these kind of explanations that are sort of code words for younger employees, or where they have the idea that an older employee who's very focused and diligent at their work may not have the energy or the drive to do the work. Like, you hear about these things all the time. That is not a bona fide occupational qualification. Somebody who's older could have tons of energy, just as much as somebody in their 20s could be a real wet sack, right? Like, age is not a determination of what kind of energy a person has, or how that person is able to be motivated to do their job, or even motivate other people to do their job if that's something the job requires. But beyond those hiring and firing and transfer and demotion decisions, age discrimination can also occur in a number of other ways in which the employer is not directly firing or demoting the employee, but is taking other steps to make that person's life difficult, or allowing things to happen to make that person's life difficult to entice them to get out of a job or out of the company. So some other ways that age discrimination can occur, in which there's really not a question of a bona fide occupational qualification, is by cutting pay or cutting benefits or other forms of compensation to try to push the person out. The employer may feel like this older employee has been with the company for a while and now makes too much money, and just arbitrarily cuts their pay. There's a good argument there that that's age discrimination motivated. Or they may cut bonuses or commission structures for the older employees to get away from having to pay them on the basis of their seniority or expertise, or quite simply their ability to do the job very well. So that can be a form of discrimination, particularly where individual employees are being isolated rather than, say, a reduction in pay across the board for a group. But if that group all happens to be older employees, there's a pretty good argument that that's age discrimination too. Companies can discriminate against employees as a group or individually. Either way, it's still unlawful if it's motivated on age and there's not a bona fide occupational qualification to justify it. Other ways that employers discriminate on the basis of age is by transferring employees to a less prestigious position. And this kind of goes hand in hand with what we talked about before, with demoting employees or terminating them. Sometimes an employer can transfer an employee into a less prestigious position on the basis of age, where there's that bona fide occupational qualification. But the employer may also be just transferring somebody out of a position of management or a specialized position as an individual contributor, and downgrades them into some other position or takes away a job title, and does that exclusively to try to push that person out of the company or out of a division or group or whatever, for the purpose of either making that person's career seem less impressive than it is, or because it'll downshift them in bonus or pay or benefits or whatever, or just because that the manager doesn't want older employees around. That's a way of avoiding having that person work underneath you, is just transfer them away somewhere else. If that transfer is being done in a way that it results in either less compensation for the employee, or it takes away job opportunities, or some other kind of benefit of performing the prior job, that's an unlawful form of age discrimination. And last, among these more common forms of age discrimination, as just a good old-fashioned harassment or hostile work environment. In this situation, the employer, whether directly through managers or supervisors, or if it's through the coworkers or other employees who are not in a position of supervision over the targeted employee, treats the employee in a hostile manner on the basis of age. These kind of claims are tricky. They're very difficult to prove, and that's because showing a hostile work environment, as far as a viable claim for age discrimination or some other form of unlawful discrimination, the actual conduct that the employee suffers has to be severe, whether it's individual acts that are particularly severe or a pervasive sort of nonstop harassment on the basis of age. And the important part there is that you can show a connection between the behavior that the employee suffers and a specific and direct connection to age. So age-related comments make it pretty easy. If you're telling somebody all the time they're too old to do the job, that they're bad at their job because they're too old for it, that makes the job simple. But if the employee is being treated poorly and there's not any kind of age-related comments to connect with it, it can be very difficult to prove that there's a hostile work environment on the basis of age discrimination. If you can't prove that there's a relationship to the employee's age, then it may be a hostile work environment in a general sense, but it's not an unlawful form of hostile work environment that gives you a claim that you can recover against the employer on. So often the employee may suffer some bad behavior, but until it hits that point to where the courts are going to say, okay, that's bad, that's really bad, the employee may have to make some alternative decisions about what to do. If the employer is tying together some of these comments or other forms of harassment together with an official act by a supervisor to demote the employee or cut benefits or take away job opportunities or particular assignments, in that case, proving harassment or a hostile work environment becomes stronger because you can show that the employer had the motivation through the comments being made, was treating the employee poorly, and then capped it off with an official act that was authorized by way of that supervisor's authority on behalf of the management. Those are strong cases for hostile work environment where there is not that specific act by the employer that ties together the motivation on age and the poor conduct. Then the conduct usually has to be so severe that no person in their right mind would sustain it and keep working there. And that's really a hard thing to sell on a jury who, look around at people they know or maybe even themselves and say, hey, it's hard to find a job out here. I'd rather have my boss or my coworkers make some comments about my age than quit a job and hope a lawsuit is going to take care of it. So it can be a hard sell to jurors, but if that environment is really terrible, then the claim may be out there, and a jury, sometimes juries do say, okay, this is bad enough. The employer should be punished for this. The employee should be compensated for it. And employee plaintiffs are successful at these claims at times, but they're very specific on the individual facts, what's being said, how often is it being said, what is the employer doing with it, has the employer been put on notice, has the employer taken any steps to try to prevent any further harassment, and most notably, has what the employee has endured or suffered been so severe that a viable claim exists. But if there is such a viable claim under any of these forms of age discrimination, then the employee does have some remedies against the employer. If the employer if the employee loses out on a job opportunity by way of not being hired, not being promoted, getting demoted or fired, or loses pay, it's easy to show a connection between a physical loss of compensation on the part of the employee or applicant, and that lost money or lost wages or benefits can be recovered by the employee in a lawsuit or other action. The employee or applicant can also recover attorney fees. There are some other financial compensation methods that may be available in a lawsuit on the basis of age discrimination. You really want to look again at the particulars of the situation to determine what the employee may be entitled to. An employee may also be entitled to reinstatement or instatement into a job that they were either removed from or never got in the first place, where age discrimination motivated the decision to not put the employee into that job or keep the employee in that job. In that situation, reinstatement rarely ever occurs on the basis of a lawsuit, and the reason for that is by the time a case has gotten to trial, it's been months, probably years, to get to that point, and by that time the employer has definitely put somebody else into that position or consolidated that job into somebody else's job. It's not exactly fair to take somebody who has filled that position and push them out of a job to put you back into a job you used to have. As a practical matter, it just seems unfair to punish one person because the employer took an unlawful act, whether the victim of the age discrimination is the one punished or the person who filled that job afterwards is the one getting punished. So courts oftentimes will not order reinstatement. Sometimes if a case gets caught early enough and it can be settled, reinstatement will occur. A problem in a lot of cases is even where the employer has the ability or desire to reinstate the employee may not want to go back. This is particularly true where there was harassment or even just bad behavior that may not rise to the level of a full harassment claim. But if the employee fears going back into the job because they're going to endure further harassment, or they expect that the employer is going to turn around and fire them as soon as possible, it doesn't make sense to force the employee to be reinstated and insert themselves back into that terrible situation. The caveat there is turning down an offer to be reinstated can cut off your ability to recover monetarily for lost wages and some of these other types of monetary relief in a lawsuit. So it's again very fact-based upon whether it makes sense for that employee to turn down an offer to be reinstated and go back into that situation. So with all of this very fact-specific kind of analysis and claim building for age discrimination, it really makes sense to work with an attorney who has experience dealing with discrimination claims. It's very easy to get these kind of cases wrong just by not understanding the way in which the courts perceive these very fact-specific scenarios. An important point to that too is that there's a very short window of time where certain steps have to be taken in an age discrimination case in order to preserve those rights and even keep the door open to be able to file a suit later if you need to. So it's important to act quickly, to make a decision whether you want to even pursue this. Talk to an attorney as soon as possible. Make sure you're getting that first step taken care of and preserving those claims and trying to get everything resolved as best as you can, or at least put yourself in the best possible situation should you have to go to trial and prove your claims there. So that's about it for this video. If you've got more questions or you're trying to learn more about age discrimination, I've got some additional information on my website And the blog that's wrapped in there. There will be links below the video that you can click on, get some more information. Of course, if you're in Texas and you've got a potential claim, you're welcome to contact my office or contact another employment attorney who's in your area. If you're outside of Texas and you're listening to the video, I'm not licensed wherever you are, so you'll need to talk to an attorney that's in your state or that's local to you and get some more information about whether you have some viable claims out there and how that attorney can help you. So that's it. So I'll see you next video. Thanks for listening.